Tony DeWitt here, Missouri appellate attorney, retired. None of what follows is legal advice. I'm here to do some video for you today to talk about an interesting subject on the law, and here it is. Today I'm going to be discussing a case about a healthcare kickback scheme that went to trial in a district court in Georgia, and the United States Court of Appeals for the 11th Circuit wound up reversing that court's judgment. The case involves an alleged illegal payment scheme made in exchange for patient referrals in violation of the federal anti-kickback statute. And that statute basically says you cannot engage in referring patients for money if they are paid in any way under any federal health care program. And I would point out that in the state laws of most states, there is a similar anti-kickback provision, meaning that even if someone is paying for something with cash, it might still violate state law, even if it doesn't violate federal law. The case is United States versus Holland, Cota, and Moore. The government accused John Holland, Edmundo Cota, and William Moore of participating in an illegal kickback scheme involving Tenet Healthcare and clinics serving Hispanic women and children. These clinics, referred to as Clinica, were operated by Edmundo Cota and his wife Tracy. In this case, the government alleged that Tenet Healthcare paid the Cotas for referring Medicaid or Medicare-covered patients to Tenet hospitals. The payments were disguised as contracts for translation services. The idea was that in exchange for paying these folks for translation services, Cota's clinics would direct pregnant women covered by Medicaid or Medicare to give birth at Tenet hospitals. Now, it's fairly unlikely that they're going to have a pregnant woman covered by Medicare because Medicare usually doesn't kick in until you're 65 unless you're on dialysis, in which case you probably shouldn't be getting any kind of, probably shouldn't be getting pregnant to begin with. Tracy Cota, one of the defendants, admitted to participating in this scheme, and she pleaded guilty to violating the anti-kickback statute, but other defendants denied having any criminal intent. The main legal question was whether certain statements made by the defendants' alleged co-conspirators could be used as evidence against them. The government wanted to introduce certain out-of-court statements from these co-conspirators under a legal rule that allows such statements in conspiracy cases. The evidentiary rule in relevant part, which is 801, Rule 801, Federal Rules of Evidence, says, and I'm going to read only the relevant parts of this part of the rule, statements that are not hearsay. A statement that meets the following conditions is not hearsay. Then we go down to 2 down there. It says an opposing party's statement. If the statement is offered against an opposing party and it was made by the party's co-conspirator during and in furtherance of the conspiracy, well, then it's not hearsay. So if you conspire with Fred next door to steal money from the federal government, and Fred pleads out and says, hey, I'll testify, you don't get to shield his statements under this rule because he is a party to the conspiracy and his statements can be offered as substantive evidence. Well, but the district court refused, saying that the government first had to prove that the defendants knew what they were doing was illegal, meaning that they had acted with the necessary willfulness. Although, frankly, I believe the statute only requires knowledge, but either way, that's what the court had held. So in order to get there, the defendants had moved for a pretrial hearing under prior precedent that requires the court to determine the admissibility of co-conspirator statements under an exclusion from this hearsay rule. The government consistently objected to how the defendants envisioned the hearing, calling it an improper attempt to conduct a mini-trial on the anti-kickback statute's conspiracy charge. The district court ruled that the government had not shown that Holland, Moore, and Cota knew that they were breaking the law, so it excluded the statements made by their co-conspirators. Essentially, the court said, we're not going to allow these out-of-court statements as evidence because the government hasn't yet proven that the defendants intended to break the law. Well, the government appealed this decision. You probably wonder, how can that happen? I thought that the government couldn't appeal when they lost. But it wasn't a full-blown trial. They didn't get acquitted. In fact, it was a paper trial on one issue. So the case is still pending. Under 18 United States Code, Section 3731, the United States can appeal a district court's decision to exclude evidence in a criminal proceeding. Here, the government appeals after the district court excluded statements from the defendant's alleged co-conspirators. We review a district court's evidentiary rulings, including those concerning the admissibility of co-conspirator statements, for an abuse of discretion. But a district court abuses its discretion per se when it bases an evidentiary ruling on an erroneous view of the law. In essence, a district court's interpretation of federal rules of evidence receives de novo review. So the 11th Circuit Court of Appeals disagreed with the lower court's approach. The appellate court ruled that for out-of-court statements made by co-conspirators to be admissible, the government didn't need to prove that the conspiracy was illegal before trial. It was enough to show that the parties were working together toward a shared goal, which could be legal or it could be illegal. The 11th Circuit explained that the hearsay rule, which usually prevents out-of-court statements from being used as evidence or substantive evidence, has an exception for statements made during a joint venture. This means that as long as people were working together on a common project, their statements can be used as evidence even if the project itself was legal. Normally, when we think of conspiracy, we think of a criminal conspiracy. Two people agree to hack into a computer system and steal money from the bank. That's a criminal conspiracy. But there are also civil causes of action for something called civil conspiracy, where parties get together and conspire to injure a person through wrongful acts like defamation or fraudulent inducement. But the rule says conspiracy, it doesn't say criminal conspiracy. And that, I think, is the important distinction that the 11th Circuit saw here. The court reversed the district court's decision and sent the case back for further proceedings. Now, the case is going to go to trial in Georgia, and the co-conspirator, Tracy, is going to get up and she's going to say, yeah, we all worked together basically to hide these kickbacks, and more likely than not, a Georgia jury is probably going to convict them, or the other folks in the conspiracy are suddenly going to see the light and understand that there's no way to beat this, and they're going to plead it out and hopefully get some kind of a good deal out of this so that they don't go to jail for longer than they really need to. Well, why is this case important? It's important for a couple of reasons. One is that if there is a violation of the anti-kickback statute, that violation of the anti-kickback statute is also a per se violation of the Federal False Claims Act, which subjects the people who engaged in it to 3 times the amount of the damage to the government, plus a civil penalty up to, I believe it's $18,000 per false claim. So if there were 40 patients in the conspiracy and 40 patients got referred, that's 40 times $18,000. That's a lot of money in a civil conspiracy for a civil penalty. And so there is a lot of money riding on this. And obviously, this case was very important to the Department of Justice because it implicated their ability to try conspiracies to violate the anti-kickback statute. And it's also important for another reason, and that is that when people steal money from the government, they are stealing money from you. You paid tax. The tax that you paid goes into funding that kind of illicit, illegal activity that takes money away from people who really need it. So it's a good decision by the 11th Circuit to allow the conspiracy to be part of the charge and to essentially permit the people who were conspirators to testify against one another about things that they said in the course of the conspiracy. And it also clarifies the rules and how the rules work in healthcare fraud cases. The government does not need to prove the illegality of a conspiracy in a pretrial hearing before using co-conspirator statements. The ruling makes it easier for prosecutors to introduce evidence early in a healthcare fraud case involving complex schemes like kickbacks. And I would also point out it's fairly common for healthcare schemes involving kickbacks to have the kickbacks hidden in some mendacious manner. Early on in some of the cases in anti-kickback statutes and Federal False Claims Act cases, you would see a doctor agree to lease office space from a healthcare company like Tenet or HCA. And if any other place that he went, he would have to pay, $150 a square foot to have the size office that he wants to have. And the healthcare corporation would give it to him for $50 a square foot. Then there is sort of a wink, wink, nod, nod kind of agreement here where we'll lease you this space for a really cheap price, but you got to send all your patients all to our hospital. You can't send any of them anywhere else. Now, nobody ever puts that in writing, but of course they make certain to understand that the lease, which is usually renewable every year, and of course it takes you a good year to get used to the office space anyway, they make sure that by having a very short-term lease, they can control and correct any physician who has the audacity to send his patients somewhere else because he thinks they might get a better deal there. So these kinds of agreements are not unusual whatsoever in healthcare. And like I said, they're often disguised in a number of different ways. Lease arrangements or, as in this case, translation services. I think that's a very good decision here by the 11th Circuit. Let me know what you think. And I'd be interested in your opinion. If you would, just drop it down in the comments down below, or you can email me at the address above. Thank you so much for watching. If you have the opportunity today, do a kindness for somebody. Make their day. And then come on back down here tomorrow. We'll talk about something else interesting. Hey, as I said at the beginning, none of what I said is legal advice. But let me tell you what, the stuff that's going to be right up here, these are the things that YouTube thinks you might be interested in going forward. Have a terrific day.